As a business leader, you've likely encountered deals that didn't go as planned, where expectations were clear, but the outcomes weren't. In this video, we explore a real-life situation that highlights why having a well-drafted contract isn't just good business. It's essential protection. You'll learn the core elements of a contract, the hidden costs of legal battles, and how to build agreements that actually safeguard your interests. Let's dive into the critical contract provisions every entrepreneur should understand before the deal is signed. A few years ago, a business owner came to me with a problem. He said, "We had an agreement with a nonprofit to do work for them, and in exchange for that work, they would pay us $14,000. But after we did the work, everything was done, the nonprofit came back and said, 'How about we pay you $8,000? And the CEO said, "Well, was there something wrong?" The nonprofit said no. And the CEO said, "Well, why wouldn't you pay $14,000? That's what we agreed to." And the nonprofit just said, "We're willing to pay you $8,000. Is that sufficient?" And the CEO said, "No, we need payment of $14,000. The nonprofit said, "Well, if you want to get paid, you'll need to accept $8,000. The CEO said, "Well, that wasn't our deal." And they said, "Well, that's the deal now. If you want the money, you need to accept $8,000. The CEO said, "Well, that's not acceptable. We need the $14,000. And the nonprofit said, "Well, then you're not going to get paid." So the CEO came to me and said, "What can we do about this?" And I said, "Well, can I have a copy of the contract?" He said, "Well, we kind of had a statement that we wrote up, kind of a statement of work, but there wasn't necessarily a contract." I said, "Well, send me whatever you have, because you had a deal, so that legally is a contract. What we need to see is what are the terms." Well, I looked at it. It very clearly said $14,000 in exchange for this work. I said, "Well, here's the problem. You are owed $14,000. You did your part. They didn't do their part. They owe you $14,000. But in order to hire me, to sue them and go after that money, you're going to pay a lot more than what's at stake here." I said, "You'd be better off accepting a payment of $8,000 than to sue them. And here's the problem. You'd like to recover attorney's fees, but in the United States, you can only recover attorney's fees if a contract says you have a right to do it, or if there's a special statute that allows you to do it." So I said, you could spend $15,000 to $20,000 in attorney's fees, but then you're only entitled to that $14,000 that you originally were entitled to. And so let's add up the money. Let's say you spend $20,000 in legal fees, and now you get $14,000. You're out $6,000. Whereas if you accept their $8,000 offer, you're ahead $8,000 compared to where you are now. Now, sure, you're entitled to $14,000, but if you have to go to court to get that money and have a judge rule that it in your favor, it's going to cost you some legal fees. And so it was at that moment that the CEO realized it's really important to have an attorney put together a contract with provisions that protect the CEO. So that's what we're talking about today. Contracts. How do we put together the provisions that are important to you? And part of that is just figuring out what are those. Now, of course, you can hire an attorney, and if that attorney sits down and talks with you about the deal and thinks about what pieces should be there, often the attorney will identify all these important provisions for you. But my hope for today is that you don't have to rely on the perfection of your business attorney, that you'll be able to identify for yourself what provisions should be there. You'll understand at the end of this section, what is a contract and how do I enforce it, and what are the different types of contracts. So we're going to talk today about what is a contract, what are the different types of contracts, and as we go through those, we'll talk about different provisions. These are just contract clauses, sometimes called terms, that basically you're saying, hey, we should have that in there, we should cover that subject. So a contract is just an agreement where both parties agree to do something or give up something. For example, I might say, hey, I'll pay you $100 to come paint my house. And you say, agreed. Well, I'm giving up something, $100. You're giving up something, the time it takes to come paint my house. Do we have a contract there? Yes. Now you might say, but wait a second. There are all sorts of terms missing. We didn't figure out what day, what color of paint to use. There's no agreement on how long it will take. And what does paint the house mean? Inside or outside? Well, courts have wrestled with these issues and basically said, as long as a reasonable person could imply those terms will be implied by a court if there's litigation. Now you might say, well, are there circumstances when there doesn't have to be a price? Well, if the price is commonly known, like if the price is listed in newspapers like it is with commodities, or if the price is generally understood, like when buying and selling a vehicle, it's probably around the blue book value. But that's up to a judge to figure out what are the reasonable terms that should be part of a deal. So, what is a contract? It's when both parties are giving up something. And then you might say, well, does it have to be in writing? No. Generally speaking, oral or spoken agreements are totally enforceable. There are a few exceptions. These are the exceptions written in a statute. It's called the Statute of Frauds. And that Statute of Frauds says, you know what, for real estate transactions, for contracts for more than a year, for certain surety type agreements where one party's agreeing to be personally responsible for another party, for certain types of arrangements, it does have to be in writing. And there are even some exceptions to that. We're not going to get into that today. For most business contracts, an oral agreement is sufficient. So of course, if you have something more than oral, like you have it in writing, that's even better. Now, the writing might be an email. It might be on the back of a napkin. It might be an invoice or a term sheet or some other informal communication. It really doesn't matter. The agreement is the exchange between the parties, and then whether it's by email or paper or recorded or on video or whatever that evidence is, that's evidence of the agreement. It's not the actual agreement itself. So even though we might talk about a legal document and we call it an agreement or we call it a contract, the agreement is actually the exchange that was approved by both parties, which is often reflected in a document. All right, so we don't have to get too technical about this, but I want to make sure you understand what is a contract. There's one other issue that comes up with what is a contract. What if I say to you, I will give you a brand new bike on Christmas, and you say, agreed. Is that a contract? No, because you didn't give up anything. It was a one-way deal. I gave up a bike, but that's a promise of a gift. It's not a contract. So keep in mind, you always have both parties giving up something. The legal term for that is consideration. In other words, both sides must have given up something, and that thing that's being given up, legally we call that consideration. You don't need to remember that term, but it is a legal term that's out there that lawyers will use when figuring out, was there actually a contract in place? So what I would think about is, was there an offer? Did the other side accept that offer? And did it involve both parties giving up something? So as we part, feel free to stay in touch with me with the resources here You'll see some links to all of my social media. You are welcome to connect with me there. I'd love to stay in touch. And if you have any questions, you're welcome to reach me at aaronhall.com. You can just reach out to me by email. My email address is aaron@aaronhall.com. It's been a privilege to be with you through this process. My hope is that through this knowledge you've acquired, you feel empowered and emboldened to avoid the problems that take down many other companies and to work better with an attorney and a CPA and even AI as you avoid legal trouble in the future and improve the success of your company. I wish you the best.